Welcome to the White Collar Files, the podcast that unravels the complex world of financial crime. I'm your host, Ethan, and today we're diving deep into the murky waters of fraud. Get ready to explore the minds of con artists, the tactics they use, and the devastating impact of their actions. Whether you're a business professional, a curious investor, or simply fascinated by the dark side of human nature, this episode will open your eyes to the pervasive threat of fraud in our society. So, let's pull back the curtain and expose the anatomy of fraud. In today's episode of the White Collar Files, we're going to dissect the anatomy of fraud, focusing on its definition and legal aspects. Fraud is a chameleon in the world of white-collar crime, constantly adapting and evolving, yet its core remains the same: deception for financial gain. Let's start with the basics. What exactly is fraud? At its most fundamental level, fraud is a deliberate deception intended to secure unfair or unlawful gain, or to deprive a victim of a legal right. It's a broad term that encompasses a wide range of criminal activities, all linked by the common thread of intentional deception. The legal definition of fraud can vary slightly depending on the jurisdiction, but generally, it includes several key elements. First, there must be a false statement of a material fact. This means that the deception must be about something significant, not a trivial matter. Second, the perpetrator must know that the statement is untrue. This is what separates fraud from a simple mistake or misunderstanding. Third, the false statement must be made with the intent to deceive the victim. And finally, the victim must rely on the false statement and suffer damages as a result. Let's break this down with an example. Imagine a real estate agent who knowingly misrepresents the condition of a house to a potential buyer. The agent claims the house has a new roof when in fact, it's old and leaking. This false statement about the roof's condition is material because it significantly affects the value of the house. The agent knows it's untrue, and they're making this claim with the intent to deceive the buyer into paying more for the house. If the buyer relies on this false information and purchases the house, only to discover the truth later and incur significant repair costs, all the elements of fraud are present. It's important to note that fraud doesn't always involve outright lies. Sometimes, it can involve omissions of crucial information. In our real estate example, if the agent simply failed to mention the roof's poor condition when they had a duty to disclose such information, this could still constitute fraud. Now, let's delve into some of the legal aspects of fraud. In most jurisdictions, fraud is considered both a criminal and civil offense. This means that a fraudster can face criminal charges brought by the state, as well as civil lawsuits from the victims seeking to recover their losses. In criminal law, fraud is often classified as a felony, especially when it involves substantial sums of money or particularly vulnerable victims. The penalties can be severe, including hefty fines and lengthy prison sentences. For instance, in the United States, wire fraud, which involves using electronic communications to perpetrate a fraud, can carry a sentence of up to 20 years in federal prison. Civil fraud cases, on the other hand, are typically aimed at recovering the victim's losses. These cases often involve claims for compensatory damages, to cover the actual losses, and sometimes punitive damages, to punish the fraudster and deter similar behavior. The burden of proof in civil cases is generally lower than in criminal cases. While criminal fraud must be proven beyond a reasonable doubt, civil fraud usually only requires a preponderance of evidence, meaning it's more likely than not that the fraud occurred. One of the challenges in prosecuting fraud cases is proving intent. Remember, for an act to be considered fraud, the perpetrator must have knowingly made false statements with the intent to deceive. This can be difficult to establish, especially in complex financial cases where the fraudster might claim they simply made a mistake or exercised poor judgment. Another legal concept that's important in fraud cases is the statute of limitations. This is the time limit within which legal proceedings must be initiated. For fraud, this time limit often starts from when the fraud was discovered, or reasonably should have been discovered, rather than when it actually occurred. This is because frauds can sometimes go undetected for years. Now, let's talk about some specific types of fraud recognized by law. One common type is securities fraud, which involves deception related to stocks, bonds, or other financial instruments. This can include insider trading, where someone uses non-public information to make trades, or pump and dump schemes, where fraudsters artificially inflate the price of a stock before selling their own shares at a profit. Another type is mail fraud, which involves using the postal service to carry out a fraudulent scheme. Despite the decline in traditional mail, this remains a commonly charged offense because it's broadly defined and can encompass many types of fraudulent activities. Wire fraud, as mentioned earlier, is similar to mail fraud but involves electronic communications. With the rise of the internet and digital transactions, wire fraud has become increasingly common. It can include everything from phishing scams to sophisticated cybercrime operations. Identity theft is another form of fraud that's gained prominence in the digital age. This involves using someone else's personal information, such as their social security number or credit card details, to commit fraud. The legal ramifications of identity theft can be complex, as it often involves multiple jurisdictions and can be challenging to investigate. Insurance fraud is yet another category, involving deception directed at insurance companies. This can range from individuals faking injuries to claim payouts, to large-scale schemes involving healthcare providers billing for services never rendered. One of the most infamous types of fraud is the Ponzi scheme, named after Charles Ponzi, who became notorious for using this method in the 1920s. In a Ponzi scheme, the fraudster pays returns to earlier investors using the capital of newer investors, rather than from profit earned by the organization. The scheme requires a constant flow of new money to survive, which is why Ponzi schemes tend to collapse when it becomes difficult to recruit new investors or when a large number of investors ask to cash out. The largest Ponzi scheme in history was orchestrated by Bernie Madoff, which came to light in 2008. Madoff's scheme lasted for decades and involved billions of dollars, devastating thousands of investors when it finally collapsed. The Madoff case led to significant changes in financial regulations and highlighted the need for better oversight and fraud detection mechanisms in the financial industry. Let's also touch on some legal doctrines that come into play in fraud cases. One is the concept of fraud in the inducement. This occurs when a misrepresentation leads someone to enter into a contract or agreement. For example, if a company lies about its financial health to secure a loan, this could be considered fraud in the inducement. Another important legal principle is fraudulent misrepresentation. This is a civil tort that allows a person who has suffered loss due to a false representation to sue for damages. To prove fraudulent misrepresentation, the plaintiff must show that the defendant made a false representation, knew it was false, or was reckless as to its truth, and intended the plaintiff to act on it. The fraud on the market theory is a legal doctrine specifically related to securities fraud. It assumes that in an efficient market, all public information about a company is reflected in its stock price. Therefore, if a company makes false statements that affect its stock price, anyone who buys or sells the stock during that period can be considered a victim of fraud, even if they didn't directly rely on the false statements. It's worth noting that fraud law has had to evolve rapidly in recent years to keep up with technological advancements. Cybercrime, cryptocurrency fraud, and social media scams have all presented new challenges for lawmakers and law enforcement. For instance, the anonymity provided by cryptocurrencies has made them an attractive tool for fraudsters, leading to new regulations and enforcement efforts in this area. International fraud presents its own set of legal challenges. With the internet enabling cross-border transactions, fraudsters can often operate from countries with lax enforcement, making it difficult for victims to seek justice. This has led to increased cooperation between law enforcement agencies across countries, as well as efforts to harmonize anti-fraud laws internationally. One area where fraud intersects with other areas of law is in whistleblower protections. Many jurisdictions have laws that protect individuals who report fraud, especially in corporate settings. In the U.S., for example, the Sarbanes-Oxley Act provides protections for employees who report corporate fraud, while the Dodd-Frank Act established a whistleblower program that provides financial incentives for individuals who report violations of securities laws. It's also important to understand that fraud doesn't just impact the direct victims. It can have far-reaching consequences for society as a whole. For instance, large-scale corporate fraud can shake investor confidence, potentially leading to market instability. Insurance fraud drives up premiums for all policyholders. Tax fraud reduces government revenue, potentially impacting public services. These broader impacts are often considered by courts when determining penalties for fraud. From a legal perspective, one of the most challenging aspects of dealing with fraud is striking a balance between protecting potential victims and not overly burdening legitimate business activities. Regulations aimed at preventing fraud can sometimes create compliance costs that smaller businesses struggle to meet. This is an ongoing debate in many jurisdictions: how to craft laws that effectively combat fraud without stifling innovation or creating undue burdens on honest businesses. Another interesting legal aspect of fraud is the concept of fraud by hindsight. This refers to situations where a statement that was believed to be true when it was made later turns out to be false. Courts generally recognize that not all incorrect statements constitute fraud, and they try to avoid judging past actions based on information that wasn't available at the time. This principle is particularly relevant in securities fraud cases, where companies' forward-looking statements may not pan out as expected. It's also worth noting that in many jurisdictions, there's a legal duty to disclose certain information in specific contexts. For instance, in many real estate transactions, sellers are required to disclose known defects in the property. Failure to do so could constitute fraud. Similarly, public companies have extensive disclosure requirements under securities laws. Understanding these disclosure obligations is crucial for businesses and individuals to avoid inadvertently committing fraud. The legal landscape surrounding fraud is constantly evolving. New types of fraud emerge, prompting lawmakers to update existing statutes or create new ones. For instance, the rise of social media has led to new forms of fraud, such as influencers promoting fraudulent products or services. This has prompted discussions about the legal responsibilities of social media platforms and influencers. In recent years, there's been an increased focus on corporate liability for fraud. While traditionally, fraud prosecutions often targeted individuals, there's now a greater emphasis on holding corporations themselves accountable. This can involve hefty fines, mandated compliance programs, and in some cases, the appointment of independent monitors to oversee a company's operations. Another trend in fraud law is the use of data analytics and artificial intelligence in detection and prevention. Many financial institutions and regulatory bodies are now employing sophisticated algorithms to identify potentially fraudulent activities. This raises interesting legal questions about privacy and the admissibility of evidence derived from these technologies. As we wrap up our exploration of the legal aspects of fraud, it's clear that this is a complex and multifaceted area of law. From the basic elements that define fraud to the sophisticated schemes that exploit loopholes in the system, understanding fraud requires a deep dive into both legal principles and human psychology. Fraud is not just a legal issue, it's a societal one. It erodes trust, undermines financial systems, and can have devastating personal impacts on its victims. As such, combating fraud is not just the responsibility of law enforcement and the legal system. It requires a collective effort from businesses, individuals, and society as a whole. Education plays a crucial role in fraud prevention. By understanding the various forms fraud can take and the red flags to watch out for, individuals and organizations can better protect themselves. This is why podcasts like the White Collar Files are so important. They help raise awareness and promote financial literacy. As we conclude this episode, I hope you've gained a deeper understanding of the legal framework surrounding fraud. Remember, knowledge is power in the fight against financial crime. If you found this episode informative, please subscribe to our channel and give us a like. Your support helps us continue to shed light on these important issues. Until next time, this is Ethan, reminding you to stay vigilant and always follow the money trail.